Can each justice identify themselves, beginning with Justice Link?
Justice Link.
Justice Gaziano.
Justice Lowy.
Justice Bud. Justice Cipher.
Justice Gapter.
Okay, all justices accounted for. Do we have Ms. Farmer?
Yes, good afternoon.
And do we have Mr. Reedy?
Yes, you do, Your Honor.
Okay, so hopefully we have Clerk Keneally.
Yes, Judge.
All right, would you please call the case and we commence? I apologize for the difficulties earlier. Clerk Keneally, would you call the case?
Yes, SJC-12872 in the matter of an impounded case.
All right, Ms. Farmer, on behalf of J.P., you may proceed. Now, the protocol, as I think was explained to you, is we'll give you in the ballpark of 3 minutes to speak without interruption. If you wish to invite questions earlier, you can invite them. Then we shall proceed with the most senior justice, which in this case is Justice Link, asking questions first. We'll go by seniority. I will go last. After I ask questions, then each justice, if they wish, may have follow-up questions, and then we'll move on to Mr. Reddy's argument. If any of you are on a landline and have a speakerphone, please make sure your speakerphone is your cell phone is on silent. And I think the sound quality is much better than it was earlier. So why don't we proceed? Ms. Farmer, you may proceed.
Thank you. May it please the court. I represent Appellant J.P., who appeals from an order of commitment on insufficiency of the evidence on the required criteria. Although J.P. does not challenge the finding of mental illness in itself is insufficient for commitment. There must be a nexus between the mental illness and the requirement that there is a likelihood of serious harm. Of the three disjunctive prongs in the definition of serious harm under General Laws, Chapter 123, Section 1, this appeal focuses on the court's order of commitment under the second clause of prong 2 and under prong 3. Both prongs require proof that the anticipated serious harm would be imminent. In addition, commitment would not be authorized if there were less restrictive alternatives to hospitalization where the dual roles of the staff, protection of others, and J.P. himself, as well as rehabilitation of the mentally ill individual could be met. Under its decision in the matter of a minor issued just last month, the SJC held that the judge was obligated to consider less restrictive alternatives to hospitalization, and therefore the petitioner was obligated to present evidence rising to the burden of proof as to what options were considered and why they were rejected. In this Section 7 and 8 case, the burden of proof under all required criteria is proof beyond a reasonable doubt, and that burden rests at all times and on all criteria on the petitioner. With regard to the second clause of prong 2, that requires evidence that others are placed in reasonable fear of violent behavior and serious physical harm to them. Relying on cases under the Protection from Abuse statute, General Laws 209A, J.P. argued that this clause includes the requirement that the reasonable fear be based on an objective, not a subjective standard. The amici have all agreed that an objective standard must be applied to the commitment criteria. Prong 3 requires proof under a heightened level of risk to the individual and himself in the community. Given that J.P. could not return to his mother's home, the appellate division saw that as being homeless and surmised that homelessness is a factor sufficient to meet prong 3 criteria. J.P. and the amici disagree with that. In and of itself, homelessness is too broad a term to be applied to prong 3. Although J.P. was unable to return to his mother's home, he was not without an option to meet his physical needs. J.P. described how he would meet his needs in his safe discharge plan. The issue of housing status may only be raised under the question whether an individual can meet his physical needs in the community. Thank you. I will now accept questions.
Yeah, Justice Link. Justice Lank, you need to unmute.
Goodness, I did that again. I'm so sorry. I'm trying not to be intrusive, but if I turn off the unmute button. But anyway, you can hear me now, I hope?
Yes.
Oh, good. All right. So I was wanted to pursue the question of homelessness and what you mean by having it be I know you're saying it can't stand alone, but doesn't it play some role in the determination of whether somebody has a very substantial risk of harm to himself or herself?
Preliminarily, I would strongly recommend that the court not use the term homelessness because that's way too broad, and it really creates a stigma for anybody who does not have permanent housing. But I would suggest that the individual's ability to meet his physical needs, his medical needs perhaps, may be affected by his housing status. Permanent housing is not necessarily a requirement and is not a requirement. But the thing is that an individual may have the ability to meet their needs. That's actually the finding of this court in Commonwealth versus Nassar. Not really a finding, but the SJC noted that those two individuals were living semi-nomadic lives, and yet they were able to meet their needs. So I would suggest that it has to be a very closely circumscribed question, and it has to be very fact-intensive as to how you will respond to the question under the totality of the circumstances.
Mm-hmm. And of course, the judge doesn't have to believe the person who's saying, I've got this plan for myself.
No, the judge does not have to, but what has to happen is the petitioner is obligated to prove that the person cannot meet his needs in the community. In this case, the petitioner did not represent any information in that regard. Only information that the petitioner relied on was that JP could not return to his mother's home. So I would suggest that where the petitioner failed in its burden, really this question doesn't come up in this case, but it is an important question in so many cases that do come before the courts.
Mm-hmm. Yeah. So what you're saying is, could you formulate the test for me then?
I would suggest that the test is whether an individual can meet his physical and medical needs, notwithstanding whether or not he has permanent housing.
Okay. All right, thank you. That's it.
Thank you.
Justice Gaziano.
Thank you. A few questions along those same lines. So if we take out footnote 10 from the appellate division argument, which you strenuously object to, the categorical approach to homelessness, and forgive me if I don't have a better term for it right now, would this stand on its own? Because and help me with the record here, because the finding is that he couldn't return to his mother's home. Did the petitioner actually have alternative plans? And I might have missed that from the record.
Yeah, the petitioner did not have alternative plans. They had really focused on the fact that mother would not accept this individual home, right. And but they had a much more important burden to meet. When you talk about less restrictive alternatives, which this can actually apply to this particular argument, under the minor case, the petitioner is obligated to show what they investigated and why these issues are rejected with regard to this particular JP, with regard to JP.
But,
yes, he had plans.
And we can look at the minor case, which I'm familiar with, of course, but did JP, it's JP, correct?
Yes.
Okay, did JP himself come up with, I'm not going to go to my mother's, but here's where I could go? Or that wasn't?
Yes, he did. He testified. Okay, thank you. JP testified that he actually had a plan. First he was going to go to the ATM, make sure bills were paid and he had money, which is a good thought. He was going to go to a hotel and at the same time get some friends involved. One of the friends was going to go to his mother's house, get the extra set of keys for his car, pick up his medication, which was in the house, whatever. But because mother did not want JP in the house out of consideration for her, he was having a friend do it. Then he was going to stay in a hotel for a little bit, and he was going to source friends for whom he could work. He was going to get a job. Once he had a job, he'd be able to get housing.
And
so he had a well-thought-out plan.
Right, and apart from this categorical approach that you want us not to use or not to endorse, we should be looking at to see whether or not there's any plans for, as you say, to meet his needs, so we could be confident that he's going to take his meds and he's going to go take care of his health, correct?
Whether or not he's going to meet his needs. In terms of taking the medication, JP had also indicated to the court that where he had his medical treatments, where he went for medicine, and he also said, hey, listen, if I can't get to my prescriber fast enough, I will take the prescription from the hospital. That being said, we also have to remember that every individual has the right to accept or reject treatment unless if they lack capacity, which is not an issue here in this case, but because there was a stipulation at the end. But the thing is that some people choose not to take medications, but that does not mean that they now have to be committed. If the question is whether they're going to suffer injury or harm as a result. It is a fact-intensive inquiry that the petitioner didn't even raise.
Thank you for answering my questions.
Thank you.
Yes, I want to talk about what evidence Dr. Lee could consider. And in doing so, I'm not going to, in my questions, address whether or not the evidence was actually admitted, but just what he could have relied on. So the St. Luke hospital records, the emergency room records, they weren't actually admitted in evidence, correct?
Correct.
Within those records, there was a statement of the mother's fear. Is that correct?
No, that's not correct. It wasn't a mother's fear. It was the mother who, after, spending so much time with her mentally ill son, felt that she could not have him come home. The mother never said she was fearful.
Okay, so the only evidence of the fear is a call that the social worker had and told Dr. Lee about?
The social worker apparently forwarded the messages to Dr. Lee, so apparently he listened to them. The mother, again, there's no indication that the mother said in the phone messages that she was fearful of her son. She said that she didn't want him to come home. She was absolutely adamant she did not want him to come home. Dr. Rose Marin had testified that, mother said that she's had a lot of anxiety from, this situation, and she wants to go into an assisted living. It wasn't working anymore, the living situation, but that is different from whether or not a person has fear of serious physical harm.
Well, I'm not going to incorporate any of this into the standard yet. I'm just trying to understand whether there was a statement objected to or not that was admitted of the mother saying that she had a fear of JP.
No, there was not.
Okay. All right. And so you're saying to the extent that Dr. Lee referenced anything like that, he just didn't have anything based on the record?
Correct.
Okay. All right. Now, on the sufficiency of the evidence, you've got the issue of Dr. Lee's subjective fear. Assume that the fear has to be objectively reasonable under prong 2.
Right.
Dr. Lee did, based on the emergency room records, based on his interactions with JP, based on what he heard about what the other patient was told by JP, and a number of other considerations, formed an opinion that prong 2 is satisfied. Is that right?
That appears to be so, yes.
why isn't that enough to that opinion of the doctor enough for the sufficiency?
Because there is no evidence there under prong 2, that second part, that they were placed in reasonable fear of violent behavior or serious physical harm. So that's where you come in. It's not just a matter of a person having a bad personality, perhaps just really wanting to get his way or what have you. It really has to go much higher before you can commit a person, before you can take away his liberty. And in this particular case, the actual evidence of what it was so far short of that. There was really no evidence, no manifestation of any kind of violent behavior, nor a threat of actual violent behavior. Even Dr. Lee said, no, he did not threaten me with consequences, but he would, when he lowered his voice, he would lean in. Well, people, when they lower their voices, they lean in so you can hear. That he was clenching his teeth. A lot of people clench their teeth. All of these things, even individually or taken together, do not rise to that level that's required for the violent behavior, fear of violent behavior, of serious physical harm.
Now,
and one of the things, go ahead.
One of the, Dr. Lee testified, tell me if I have this wrong, that he had information that he based his opinion on, that another patient, that J.P. had threatened to kill the other patient.
There was the statement, the patient came from what Dr. Lee testified, my understanding is, because it wasn't quite clear, the patient came to Dr. Lee and said he threatened to kill me. Now this is the one person that there seemed to be some verbal dispute between each other. We don't know when or where that occurred. But the thing is, it was, the statement made. And those statements are made in conversation sometimes when people are trying to make a point. It's not a good thing to say, but those things are said. The question is, was there any threat behind it?
Yeah, I know. I'm not asking whether the judge should have decided what the judge decided. I'm trying to figure out whether the evidence was.
Sure. Yeah, there was some statement.
Okay.
Yeah.
And then Dr. Lee indicated that, tell me if I have this wrong, in his experience that J.P. was one of the most paranoid patients he had ever treated, and that he felt threatened by the patient. Is that correct?
He made the statement that he was one of the most one of the most paranoid people he had met. That does not mean that he was violent.
No,
Separately, the Dr. Lee suggested that he felt threatened.
Okay.
Yeah. He did say that subjectively. Yeah.
Okay, but was it in the context of saying that he was one of the most paranoid patients he'd ever met?
I don't think it was. I think it was part of their proof of mental illness. Okay.
And the statement that you're saying concerning the 209, where there's an inference being drawn that was a 209A, your position that should be given no weight?
No weight at all. I mean, let's look at it this way. On a 209A, you don't get committed. You don't get brought to an emergency room. A 209A, you get brought to court under, a petition of the person who feels they're a victim, and then
I'm not asking you about the sufficiency of the evidence with that question. I'm asking about the admissibility of it.
Oh, the admissibility of it?
Yeah.
I would say it's unreliable for sure. It's unreliable in the context, and from a matter of law, it's simply not the way things happen.
And JP's expert, Dr. Rosemarin, said that JP was angry, paranoid, psychotic, and gaze-faced and challenging. Is that right?
Yeah, he had very strong symptoms, yes.
Okay. So I guess the question is not what the judge should have decided, but whether or not, with the expert opinion that's being given by Dr. Lee and all that other evidence, your view is that that's not sufficient to satisfy the burden of production. Okay, thank you.
The burden of proof, yes. I do not believe it rises to the level required.
Well, I'm not asking about the burden of proof. I know the burden of proof is proof beyond a reasonable doubt. That's for the trier of fact. I'm asking about the burden of production to satisfy a sufficiency.
I would say that the petitioner did not produce sufficient evidence.
Okay, thank you.
Thank you.
Justice Budd.
Hi, good afternoon. I'm wondering what would have been sufficient here? What would have been enough for an objective fear of violence?
If there had been a reasonably recent episodes of a physical altercation, threats of physical altercations directed at the mother or anybody else, but directed at the mother or even maybe Dr. Lee, that may have risen to the level required. Of course, you also then have the problem of imminence. Is this going to happen again? But trying to answer this most directly, I would say that you have to have some evidence that there has been that physical violence in the fairly recent past.
So it can't just be first of all, it can't be a threat of physical violence. That must count. No?
It can't. If the threat of physical violence was connected with an actual action towards the individual, that might count.
So you have to have an action with words that constitute a threat? Is that what you're saying?
I would agree. Yes, that's what I would say.
And in terms of, are you saying that Dr. Lee could not rely on the report that he got from another patient that J.P. had threatened that patient?
Well, the thing is, we have to remember this is also a person with a mental health diagnosis, apparently, and we don't know how that manifests. So I would say that is unreliable unless he actually knows the person, and he testified she was not his patient. So although he may have seen her, what have you, we don't know who that is. So we don't know where in this person's psyche this statement is coming from.
Okay, but
so I would say it's very unreliable.
Okay, all right, that's all. Thank you.
Justice Safer.
Thank you. Are you saying that in no circumstances should where somebody is returning to or going to be factored into the threat component?
I do not.
Component.
Let me answer it this way. Number one, you have a parent who, has been living with a mentally ill person. I think we can all assume that might have been stressful, and she appears to be more of an elderly person. So, that in itself has its own anxiety. So his not being able to go back there is not a huge issue other than the fact that obviously he's going to need some interim and then long-term housing. We also have to look at the problem that if a person is put into a hospital and mother then says that, well, you can't come home, this person is unable to actually do housing searches, which are very complicated these days, even before the virus. So I think that you have to look very carefully, what is this plan and is it realistic? If this individual
so you're saying you do look at the plans, where the person would live when balancing all this out.
Oh, absolutely. Absolutely. He doesn't have
would you also factor in that there's nowhere to go?
Only if there actually is nowhere to go. I mean, if this is a person who says, listen, I've been living in the woods and I'm going to go back to the woods and that's my lifestyle, then you have to look to the question, can he nevertheless, living in the woods, access food, access medical treatment, and what have you? Again, going back to Cohn versus Nassar, the comment that this court made back in 1980. that, well, these people who are semi-nomadic nevertheless could meet their daily needs. So it is a very complicated, I agree, a complicated analysis, a fact-intensive analysis, but it is an analysis that must be made.
Okay, thank you.
Justice Kafker.
So he's not just homeless, he's also the most paranoid patient they've dealt with and confrontational. He's had some kind of altercation, at least, verbal altercation with another patient. Doesn't that figure in? We're not just dealing with homelessness and, some outdoorsy person. We're dealing with someone who's got mental illnesses that makes him confrontational and paranoid. How do we deal with that combination?
Again, I think that you have to look at the whole situation. In this case, he apparently was very paranoid, and Dr. Rosemarin agreed. He was very paranoid when he came in, but he was on the descent of that. He was coming out of that, and he then was able to, number one, note, I need my blood pressure medication. And when he was not being cooperated with by people were not giving him his necessary medication, he became agitated, apparently, but that is necessary for him, and he wanted it, and it's understandable.
Yeah, I'm just trying to understand, though. You're saying we don't take homelessness into account, and I understand why homelessness alone shouldn't be a factor, but we have this type of person on the street, a confrontational, and we've got a trained psychiatrist finds him dangerous, threatening. So how is a normal person he's going to run into going to react to him? It just seems like that's all part of the mix in this totality that we're analyzing. And it should be a relevant factor that he's, got nowhere to stay and he's belligerent at a minimum. No?
I don't know that there was evidence that at the time or just going up to the time of the hearing he was continuing to be belligerent. He did testify for himself. When he first came in, he did not want to be there. He felt he was not mentally ill. Dr. Lee and Dr. Rosemarin both decided that he had a significant illness at the time, but he seemed to have improved. And the records seemed to show that he had been improved. If you had been looking at him as of when he first arrived, there might be more emphasis placed on the mental illness and how can somebody with that mental illness meet his needs. But as he is improving, then the question becomes, okay, we've got to look at this improvement, and from where he's at the time of the commitment hearing, he appears to be able to meet his daily needs. And he had a logical, well-rationed, reasonably broad plan for how he was going to resume his life in the community.
I'm focusing on the sort of the global question you're asking us to answer, okay, which is how to take into account homelessness. And I understand and agree with your view that it alone, even in combination with mental illness, is not enough. But when I'm starting to deal with a homeless, belligerent, paranoid, mentally ill person, I start to say, that person may end up his safety is endangered by his personality in combination with the fact that he's not living in a secure environment. Is that not fair?
It's so difficult because the words are so important. When you say that, and I know I brought it up myself, when you say that his personality might make it so that he's at risk. There were a lot of people whose personalities out there put them at risk, and yet they are not mentally ill, therefore they are not committable. So there you have the nexus problem of, is it the mental illness that is causing it, or is this just his personality? But I think that with regard to homelessness, if you look at at a Webster's dictionary or whomever, they will say a person is homeless if they have no permanent housing. That's where I say it's overly broad. You cannot look at it like that. It's just whether or not he can meet his needs out in the community. That includes finding shelter, but shelter does not necessarily mean a home. So you have to look at all the different factors of his life, and where he had been living with his mother, not going back there. You have to look at his plan, which I suggest was a good plan.
In my case, I'm just trying to imagine this type of person in the shelter, and other places where he's in close quarters with strangers, with his combination of mental illness and homelessness. It becomes very tricky what's an appropriate consideration. But I think you've answered my question, so I'm all set, Chief. Thank you.
Thank you.
This is Chief Justice Gantz. I've got a few questions. As to the second prong, is it your view that it is purely objective or that it's also a subjective objective? That is, that there must be evidence that people or a person was indeed placed in fear, and also that particular fear was reasonable?
Well, I don't think that the combined standard makes sense, because what you need to do is assess the risk of this individual to other people, not necessarily just to the person who says, now I'm currently feeling fear. And I know that this is the position that was suggested by ACLU. What my feeling is that when you're looking at the standard, and this is where it differs from 209A, when you have a 209A case, the person feeling fear goes before the judge and explains why they personally are feeling fear, so they can show their subjective fear, but still is required. The judge has to look still required. Is that something that anybody would be fearful of? With Dr. Lee in this situation, he's not going to be out there dealing with a JP out in the community. He felt a subjective fear. We don't know if he has any training in risk assessment for that kind of thing. It was not brought up on testimony, but that is an issue that was brought up by the Amici. I don't think that you can necessarily say there has to be a subjective fear, because a person testifying as their experiences said, well, I wasn't afraid of this, but I'm pretty sure that everybody else there would be afraid of this. That's where the objective fear comes in. And because we're talking about an individual going into the community, it's this objective fear that you have to look at, I believe.
I'm sorry, you meant the objective fear.
The objective fear. I'm sorry. Thank you.
Right. So, if you look at prong 2, the focus of prong 2 is whether there's a substantial risk of physical harm to other persons. And
exactly.
It says that there are 2 ways to manifest it. One, you can manifest it by evidence of homicidal or violent behavior, or alternatively, it can be evidenced by the fact that others are placed in reasonable fear. I guess you would look to the conduct that caused them to be in fear.
And that requires an analysis as whether this is a fear of violent behavior and serious physical harm, or is it just fear of having to deal with somebody who maybe does not have a very pleasant personality. And I think that those are the 2 ends of the spectrum, but it has to be a reasonable fear of the violent behavior, which we haven't had, and serious physical harm, which we haven't seen.
Okay.
And that's why I believe that you want to go to that objective standard.
Do we know, I assume that each of with regard to the likelihood of serious harm, at least one of those 3 have to be proven beyond a reasonable doubt, correct?
Everything has whichever prong the judge determines is applicable, that has to be proven by proof beyond a reasonable doubt.
And do we know, I was reading the judge's oral decision. Did she rest on, it appears she rested mostly on prong 2, didn't she?
The second clause of prong 2. She mentioned the first clause of prong 2, but she said that what did she say? Some evidence as to risk of physical harm. Some evidence is not proof beyond a reasonable doubt. So my reading of it is that she really did not find on the first clause of prong 2. She only found on the second clause of prong 2, which she spent more attention to.
Right. But the ultimate finding is whether there's a substantial risk of physical harm. You've got to find that beyond a reasonable doubt, correct?
Right. And she does not identify. Well, let's put it this way. She clicked the box on the order for commitment,
right,
but that does not ask the judge to identify which prong you're relying on.
I'm sorry, well, there were three prongs to likelihood of serious harm. You're referring to prong 2, but you're referring to the second way to evidence it, correct? When you say second prong, we got too many prongs here. So
I know we have three prongs and sub-prongs. What I believe, and I may be wrong, but I believe on the order of commitment, the check boxes are simply he has a mental illness. He poses a likelihood of serious harm, and 3, there's no less restrictive alternatives. So we don't know from the order, the written order, and I have a serious problems with these boilerplate orders.
Right.
We don't know which prong she relied on. All we can go by is the oral decision, and it appears that she found under the second clause of prong 2 that he put others in reasonable fear of physical harm because mother was in fear, and because she also credited Dr. Lee. And then she also found under prong 3 that although he can protect himself physically from other people, she credited that, saying he was a strong person. Nevertheless, she felt that he could not be returned to the community because he could not protect his safety in the community. I mean, it was very vague what she said, but she did find apparently under prong 3.
I see. So if we were to, I know you're focusing on whether the evidence is sufficient. Should we also be focusing as to whether or not the judge's findings, as stated, support a finding of beyond a reasonable doubt, or is that?
That's actually an issue that was mentioned in minority, and I think that this case does present you with an opportunity to look at that problem, because I know there are other cases out there that it is a problem, particularly where you have a boilerplate order that has boilerplate findings, checkboxes, and then all you have is that this judge says, well, okay, you look strong, you can protect yourself, but I don't think that you can meet your personal and medical needs in the community. We don't know what the rationale for that is. She doesn't even discuss his plan for his safe discharge plan. So we have no idea how she evaluated that. We have no idea if she had chosen a subjective or objective basis for finding reasonable fear. This is very vague. I think you said in a minor, well, it just barely touches the legal requirements. It really does not explain them. Doesn't explain her rationale.
Okay, I've got no further questions. Anybody else have any further questions? And hearing none, thank you.
Thank you very much. I'll go on mute.
Thank you, Ms. Farmer. And we'll hear now. Is it Mr. Reddy or Mr. Reedy?
Reedy, Your Honor.
Reedy. Okay. So, Mr. Reedy, you may proceed.
Thank you. I'm going to go right to the issue of homelessness. I think that the court in footnote 10 was incorrect in stating in such a categorical way in that footnote that homelessness per se, if that's what the court was meaning by that, is a substantial risk of harm. However, I will say that it's quite evident that homelessness or any particular setting that a patient would be discharged to, whether it be a group home, whether it be to a homeless shelter, whether it be to a home where they live, where there might be physical or sexual abuse. All of those factors need to be considered when considering whether there's a less restrictive, safe alternative. And I think that the court in this case did consider those, and there's quite a bit of evidence on that. I do want to correct a couple of points, if I could, from counsel. There was a statement that was it's on transcript page 18, which is different than actually the page number at the top of the transcript page in the appendix, or the record appendix 18, and this is the doctor testifying. He also reportedly threatened his mother, and the specific statement that I am aware of is that he told his mother was, quote, "Don't you come back into the house," end quote. Now, that evidence came in without objection. So there were direct threats to the mother in this case. There were direct threats, and now we're getting to the sufficiency argument. There were direct threats to the doctor. The doctor felt threatened, and I should say he indicated that he had leaned into him and said, and this is on transcript page 31, there was another interaction we had, a few encounters, this is the doctor testifying after that, where he lowered his voice and sort of leaned in. He basically trying to encourage me to switch, and he switched doctors. And this was also after he was yelling at him various things, you're an effing punk, and so forth. So this particular appellant, he appeared to be threatening his psychiatrist. He threatened his mother. There was a threat to his to other patients, including a female patient. He threatened to kill. Even Dr. Marin, when he testified, indicated that and recognized that there was an altercation with a wheelchair-bound female. So there was numerous incidents where this appellant was exhibiting hostile intent towards others, and I think that the evidence was sufficient, and the quantum of evidence was certainly enough to render a finding of commitment on this matter. With regard to the reasonable fear and whether it should be objective or objective, and forgive me, it was Justice was raising this issue, but it really the issue of reasonableness. How would we measure that from an objective standpoint? Is it the reasonable mother at home with her psychotic son at 2 a.m. who's being threatened by saying, "Don't come back in here to the house"? Is it the reasonably trained psychiatrist? Is it the reasonably trained police officer or a stranger on the street? So I think when we look at reasonable, we need to look at not declarant as the ACLU of Massachusetts suggests, not to their words, but to how that is perceived. Because obviously fear is a subjective feeling, and it will always be a subjective feeling. Now, it has to be reasonable in the sense of the context and so forth, but I think we always have to look at, and I think the statute, when it says placing a person in reasonable fear, anticipates that we're looking at that person and whether they were placed in reasonable fear. And with that, I would welcome your questions.
Hey, Justice Lane. Then you have to unmute, Justice Lane.
All right, now you can hear me, right?
Now we can hear you.
All right. I'd like to ask you the same question I asked your sister, which is, could you please articulate a standard for when for dealing with without shelter? and when that's a factor and how we should use it as a factor.
Well, I don't know if there is a particular standard. I think it's a factual determination as to whether shelter is, or the lack of shelter places one in reasonable fear, or in a substantial risk of harm. And I think it depends. In this case, with someone who was psychotic, who was paranoid, who, given paranoia, and given what even Dr. Rosemary said, that paranoid people can react in harmful ways because of that paranoia, then the fact of the appellant's homelessness is would be given more weight by the trial court. But in and of itself, I think it's a factor I think it's a factor to consider, but in and of itself, I agree that it's not a per se substantial risk. It really depends. In that same way, as I suggested, there's other settings, wherever that patient would go, we have to determine whether that would be safe for that patient to be discharged. Would they be at substantial harm? They might be at substantial harm for returning to their own home, depending on the circumstances of that home. So, those are the circumstances we need to look at it. So it's one factor, and I frankly think that the footnote 10 was inartfully written, and certainly a part of the dicta, but not part of the holding of that case as I read it. So I don't really have a standard by which it would, homelessness should be considered, should be, determined or considered, but I think it's a factor. It's a factor on whether a person can be safely discharged.
Okay, thank you. That's all I have.
Justice Gaziano.
No questions, thank you.
Justice Moe.
Yes. Could you tell me, please, what you think in light most favorable to your client the evidence is of very substantial harm to himself, to JP?
To himself or to others?
No, to himself.
Well, there was a history of suicidal ideation. I don't think, frankly, that was the strongest case. I think that the real issue is his potential harm to others and his placing others in reasonable fear of bodily harm. There were reports of prior harm.
That's why, if I can just stop you for a moment, that's why I'm asking you about prong 3. We'll get to prong 2, but are you conceding there wasn't enough for sufficiency on prong 3?
No, not on prong 3. I would disagree with that, and I'll tell you why, Your Honor. This was a situation where this was a patient who was extremely paranoid. He had an intense gaze. He had exhibited threatening behavior towards others. He had engaged in racial epithets on the unit. And so if you transport that psychotic person out into the community, and you place him in an unrestricted setting where there's not mental health workers and psychiatrists and nurses keeping other people from him, then I think it's reasonable to infer from that, Your Honor, that this individual, the appellant, would invite, as the judge indicated in the decision, would invite retaliation in the community. So I think in that way it would place him at risk in the community, which I believe would meet the substantial harm requirement required on prong 3.
So Dr. Lee testifies as to his opinion as it relates to JP. There are some objections in the record to certain evidence. And the objection grounds were unclear, but a lot of the objections seem to be, well, I'm objecting to the emergency records for their truth. And the judge seems to make the point that, well, I'm just trying to get Dr. Lee's opinion. do we, where there's been an objection to the grounds for Dr. Lee's opinion, do we excise out in the sufficiency argument all of those? For example, the emergency room records don't reference an actual threat, whereas you just relied on the transcript where Dr. Lee, without objection, testified to the threatening behavior. So do we have to sort of excise out everywhere that JP's lawyer did make an objection?
Where he did or did not?
Where he did. Where he made an objection. The judge.
Oh, okay.
Well, certainly, if Dr. Lee could consider that information for its truth, but it shouldn't have gone into the truth of it shouldn't have gone into the equation. In other words, Dr. Lee can consider it in formulating his opinion, but the judge can't consider it for its truth. Does that matter here? And let me be specific as it relates to what is in the emergency room records relative to what the mother said.
Right. Well, I think it wasn't quite clear, and I agree with you as to some of the grounds of the objections, or in some ways, what were the grounds that the information was actually allowed in some cases. But with regard to the emergency room records, I believe the case law is strong on this in the Boshi matter, where if the declarant has a special relationship with the subject who is in the emergency room, that does allow for information to be considered.
Well, the records have to be admitted. There has to be an exhibit. You want to get in the second level of hearsay of a document that wasn't admitted in evidence.
Well, I think it was admitted, Your Honor. Not the records weren't admitted, but the testimony concerning those records was without objection in many cases. So I think
the records. Please stop me if I have this wrong. The emergency room records, which were completely permissible for the doctor to rely on, were not admitted in evidence.
That's absolutely true.
So the analysis of whether the second level of hearsay in that record would be admissible, you can't get to the second level of hearsay because the first level is not satisfied.
Well, getting back to your first question, I think, can the judge rely on Dr. Lee's opinion around these potential threats to the mother? And I think that she can, because it does form in part, a basis for her opinion. So I guess I understand Your Honor's consideration and whether you can excise that out or must excise that out. I think that if it was not objected to, then I think that the testimony should stand for what it is. And I think that objection is waived. And as it pertains to the basis of Dr. Lee's opinion, I think he can consider it. And I guess the issue really is
now exiting Barbara Lang.
Maybe I'm not hearing this.
No, I understand. I think I lost you for a minute. One last question.
Yeah. Okay.
If I'm not asking whether the burden of persuasion shouldn't have been satisfied by this particular judge. The evidence was sufficient. That's up to the judge. Considering what the basis for the opinion here was, that Dr. Lee gave an opinion relative to requiring a civil commitment under 7 and 8, does that satisfy sufficiency?
His opinion, yes, I believe it does. And remember, it wasn't just Dr. Lee's testimony. It was also Dr. Rossmarin's testimony with regard to his observations of the appellant and the appellant's presentation before the judge, and the judge has every right, the trial judge has every right to evaluate credibility and demeanor of any witness, and she certainly had that ability to do that in this case. So I think that there was
now joining Barbara Link.
Thank you very much, counsel.
Thank you.
Justice Budd.
I have no questions. Thank you.
Justice Seifer.
I have no questions. Thanks.
Justice Kafker.
I'm just trying to make sure. So you feel both prong 2 and prong 3 are viable here, right? That the judge's decision can be affirmed on both of those grounds. Is that right?
Yes, Your Honor. I believe that, Mr. Justice, that is true.
Yeah, I'm just trying to find. I read the decision. So the judge writes, there is evidence that others are placed in reasonable fear of physical harm from him because of his aggressive nature. That's the primary thing we should rely on for that point. Is that right? On 111?
With regard to, I believe so, on prong 2.
On prong 2.
Reasonable fear, yes. Placing others in reasonable fear of being harmed.
Okay, and then and then I'm just trying to, because we got sort of slim findings on some of this stuff. So, and I do believe as a corollary to that, I think there's a very substantial risk that his judgment is so affected by his paranoia and his agitation and his contrariness that it would affect his safety and the safety of others. So that's the prong 3 finding that we should rely on?
Yes, that's right.
Okay. All right, that's all I have. Thank you.
Thank you.
Sorry, go ahead.
No, I was just going to say that the evidence of that is his conduct. What his conduct would look like in an unstructured setting. That being, as in this case, someone who is homeless, but in an unstructured setting, what would someone who is yelling racial epithets, who's challenging people, who's staring at people, who is threatening to kill an individual, what kind of conduct, what kind of reaction would he have in a community? And we think that kind of, that he would provoke a substantial harm, risk of harm to himself.
Thank you. Okay.
I do worry about prong confusion because we have the likelihood of serious harm element, and then there's a third element which is not in the statute but is by our case law, that there's no less restrictive alternative.
Right.
And I understand that whether somebody is going to be on the street may relate to whether there's a less restrictive alternative in terms of what the alternative would be to having the person be housed. But as to likelihood of serious harm, isn't that really reserved for the person's going to freeze to death? Or isn't that, it also speaks not merely a substantial risk. The others are substantial risk. Third is a very substantial risk. Shouldn't that be quite narrow?
Well, it is a heightened standard. I don't know if it's narrow in terms of the scope of of what the court should look at. When we're looking at it and just say, well, it's just because it only relates to someone who might freeze to death on the street. I don't think that's what it means. I think is that patient's judgment so impaired that it would lead to a very substantial risk of physical impairment. And in this case, I think the evidence is that the appellant's behavior, his conduct, his provocative nature, and his lack of judgment around that conduct would substantially would impair his judgment to a point where he would be placed at substantial risk in an unstructured setting where there wasn't staff separating him from other people and so forth. So I think I agree that it's a heightened standard. I'm not sure I agree that it's limited to, in fact, I don't agree that it's limited to someone freezing to death or being malnourished and starving to death or becoming dehydrated or so forth. I think that it's broader than that. I think the statute anticipates that, and I think that it's proper to consider other elements other than sort of basic survival on prompt 3.
I mean, ultimately, what you're essentially saying is that if a person is likely to have the crap beat out of him if he's on the street, that would fit prong 3. I mean, isn't that ultimately what you're saying? Is that this guy may be so combative and that someone's going to beat him badly? Is that ultimately what the analysis is?
Well, I think that it's a consideration, absolutely. And I think that it's not specific to that issue of whether he's going to get the crap beat out of him. But certainly, there's certain behaviors that we know in an unstructured setting would invite retaliation, and certainly. So I think that yes, that kind of behavior from a psychotic person who cannot control themselves in the community without safety of staff or others around him to protect him, that yes, that would place him at I think it's logical that it would place him at a risk of physical harm, substantial risk of physical harm.
As to the second prong of the second element, the judge made reference to the fact that this is a big guy and apparently an unusually looking guy. Can that be factored in? I mean, is it that big, strong persons have a greater risk of a substantial risk of physical harm to others than smaller, less physically powerful people?
All right. I don't think it can be factored in terms of whether they're they place others at imminent risk of harm because of their violent behavior. But I think if you look at whether someone is placed in reasonable fear of being harmed, then I think it's fair to look at the demeanor of the appellant in this case. I think it's fair to look at his capabilities. If he was a wheelchair-bound person and he was threatening to assault somebody physically, well, that would be a different. Would that fear be reasonable for a person to fear that, to fear being assaulted by that person? Maybe it would, maybe it wouldn't, but it'd be quite different if that person was an imposing person who had indicated that he could handle himself in bar fights, and looked angry and capable of hurting somebody. So it doesn't, I don't think, factors into the direct evidence as to whether they are assaulted per se, but it does place in the evidence, I believe, using the subjective standard, which I think is I think is the standard that should apply in this case, should apply and allow that person to be placed in reasonable fear of harm. And I think when you look at the reasonable fear again, we think about his mother in this case, presumably an elderly woman in the house with this imposing person who was psychotic. I think that does factor in to that analysis. And I think it's fair for a trial judge to consider it.
I'm staring at my computer screen, which has before it 123 Section 1 in the definition. But if a judge is going to rely on prong 2 to find the likelihood of serious harm, doesn't the judge have to make a finding beyond a reasonable doubt that there's a substantial risk of physical harm to other persons? Isn't that the finding? There may be as to what the evidence is. I mean, it goes on to say, as manifested by evidence of homicidal or other violent behavior, or evidence that others are placed in reasonable fear of violent behavior and serious physical harm to them. But isn't the real finding that there must be a substantial that the judge must find beyond a reasonable doubt that there's a substantial risk of physical harm to other persons, and that in supporting that finding, the judge can point to this evidence to support that finding? I mean, I worry that we're sort of putting the reasonable fear of violent behavior as the ultimate issue for prong 2, but it's not the ultimate issue. It's only evidence of the ultimate issue. Isn't that right?
Well, I'm reading also from the statute and they're not and. The statute's written where there's these breaks where it says evidence of homicidal or other violent behavior, or evidence that others are placed in reasonable fear of violent behavior and serious harm to them. Or, and then they go
right. But those both follow as manifested by evidence. I mean, that's the alternative ways in which the evidence. That's the manifestation of it from the evidence that the or comes from that you're describing.
Yeah. Well, that's true. Yeah, no, I understand that reading. But so I guess I would say that, sure, there has to be a substantial risk of physical harm, to the other person, to other persons. And in this case, what we have is we have an appellant that's telling apparently one person he's going to kill her and telling his mother, don't come back in this house at 2 o'clock in the morning. Or telling the doctor after, screaming at him, and with, vulgar language, and telling him at one point, leaning in, you need to change me. I'm not going to be, you shouldn't be my doctor. So I think that you do have to have an element of reasonable fear, but I think these are separate under the statute as I read it. So, that I think it is fair. I think there has to be some element, I'm backtracking a bit here, I think there has to be some element of evidence of harm. However, if you place someone in reasonable fear of being harmed, if I stand over someone and wave a baseball bat in a threatening manner, I don't actually have to hit anybody with that bat. And I think that in this case, the way the appellant had presented himself in such a scary, frankly, way, with the psychotic look, his intense stare, his aggressive look, his confrontational manner, and everything else that we've discussed, I think that satisfies that element under the statute.
I have no further questions. Anybody else have any further questions? And hearing none, thank you, Mr. Reedy, and that will conclude the oral argument in this case. Thank you.
Thank you very much.